Well, good morning again, and thank you all for being here and all who are joining us virtually through Zoom. We appreciate your attendance as well. What I'm here today to do is to expound upon a bulletin we issued on Friday, creating a voluntary mediation program for use in resolving the hundreds of thousands of claims that are going to be filed. Probably most have been filed as a result of Hurricane Ida's devastation of Southeast Louisiana. And I am confident this new mediation program will be very helpful in solving claim disputes between insurers and their policyholders and getting people what they need to put their homes and lives back in order. It's a voluntary, as I said, program that we have structured with the help of two mediation services in the New Orleans and Baton Rouge areas. MAPS, the acronym standing for Mediation and Arbitration Professional Systems, and Perry Dampf, Dispute Solutions, have both signed on to agree to the terms that were outlined in the bulletin that I issued. And those terms are that those mediation firms will be paid $600 per mediation that they conduct. And for that $600, they will make available 90 minutes of time to the policyholders and their insurers and any representatives or experts or contractors, consultants that they may want to bring with them to that mediation. We did a mandatory mediation program back in the aftermath of Rita and Katrina in the Lake Charles and New Orleans areas, and successfully helped approximately 12,000 people to resolve their claims with their insurers through that program. And frankly, I got lots of thank yous, unsolicited, man on the street in line. I remember vividly with a lawyer at a Starbucks one morning complimenting me on the program, which candidly we had copied from Florida, who had 4 devastating impacts from hurricanes the year before in 2004, and Mississippi, who set up a similar program for the claims that resulted from Katrina's devastation on the Gulf Coast in Mississippi. So based upon that experience and success, we decided to not mandate, not require companies to provide it, as was done back in the aftermath of Katrina and Rita, but to set up a voluntary program that would be paid for by insurers. But if an individual, a policyholder, was desirous of having a mediation that his insurer was not willing to pay for, there's nothing to prohibit that individual and his or her insurer from fronting the cost of that mediation. The limit on the dollar amount at issue, first off, it's residential policyholders exclusively, not commercial. And the limit in dispute is $50,000 per claim that would be subject to the 90 minutes and the $600 fee that these two firms are offering through this program. And so with that said, I'd be happy to answer any questions any of you might have concerning the program. Yes, ma'am.
Why only the $50,000 cap on this?
Because of the cost. A larger event, a larger dispute with multiple parties, as commercial disputes very often have. Conflicting, perhaps, insurance coverages that are in dispute take more than 90 minutes to resolve, and therefore more than $600 in cost. So we're trying to focus this on consumers who are dealing with their personal homeowners policy, as we did in the aftermath of Katrina and Rita back in 06.
And with residential people, this is for residential only. if people, they completely lost their homes and everything, and they have more than $50,000 worth of damage, and if they're having issues with their insurance, what should they do?
Well, first off, as we always say, file a complaint with us if they are not satisfied with the handling that they are getting from their insurer. And I also hasten to add, because many people, I dare say most, are not aware of the fact that a tender of an amount by your insurance company, a payment, as they're required to do with first party coverage, when you make submit a completed and satisfactory proof of loss to your company, they have to pay you what they assess the damage claim to be worth. Once they make that offer, take their money, put it in the bank, worry not about that will be the end, because supplemental claims are always available to be asked for and to be pursued all the way up to and including litigation if necessary. Yes, ma'am. Oh, did you have a question? Yep. Yeah.
Commissioner. This is a voluntary program. What would it take for it to become a mandatory program?
First off, the first reason it's not mandatory, and it's I appreciate the question, is because of the added expense to the system. We are being stressed. Our market is being stressed significantly by this event. The latest reports from Laura are that companies have paid, and we're waiting for the July, August, September 30 data call submission from the Laura, Delta, and Zeta claims. But the June 30 report and the September 30 will be the final report that we'll get from the companies. But the June 30 report had reflected that $10.1 billion had been paid to policyholders for their claims as a result of those three storms, the bulk of it being Laura at $8.6 billion. Add to that what my colleague in Florida, where many of our companies that provide our coastal coverage in Louisiana also write in that market. His description in a legislative committee recently is that their market is in desperate disarray, the Florida property insurance market, impacting the small regional carriers that have filled the void left by the major national companies exiting our coastal exposure and, frankly, coastal exposure up and down the Atlantic and all around the Gulf of Mexico. On top of that, this event is now projected to be in the range of $20 billion to $40 billion, depending on what expert group you look at in their estimate of claims. We have seen a company fail, and that company was Gulfstream, and they did business in Florida and Louisiana, and frankly, their failure can largely be pointed to as a result of the dysfunction in the Florida market. We have seen, as of yesterday, a company withdraw from our market. I was notified yesterday that Giovera will be withdrawing from our property insurance market on a go-forward basis, as they have also announced they will be doing in South Carolina. So with the potential for $20 billion in paid losses as a result of Hurricane Ida, we are going to make this program voluntary rather than mandate the additional cost on all of the policyholders who may want to access it. Frankly, I think this is in the insurer's interest. I think that they will be happy to have this additional avenue made available to them on a reasonable basis for hopefully thousands of policy claims that are in dispute. Go ahead.
Is there a reason why a program similar to this wasn't set up after Hurricane Laura in the Lake Charles area? And
the reason for that is a federal judge, Judge James David Kane in Lake Charles, set up a program through the federal court there and utilized that means to mediate claims. Any others?
So if someone can clarify this for me. So if somebody's already filed a claim with their insurer and it's already been paid out, how does the program supplement those losses?
Well, paid out is not accurate, except in very small percentage of the cases. The only time a first-party claim, like a property insurance claim, is paid out is if they enter into a release agreement, as will be proposed in the conclusion, a satisfactory conclusion of a mediation. So some have been resolved all the way through to a release being executed, ending the right to pursue supplemental claims for that individual. But for those participating in this program, even if they have already been tendered an amount which the company feels is the full amount, they have the right to file a supplemental claim and to ask for mediation if they don't get a positive response or a satisfactory response from their insurer. So the claim remains open. The prescription period, frankly, for filing your lawsuit, if necessary, is not until 2 years after the landfall of the hurricane. Yes, ma'am.
Can you give an example of a kind of scenario that someone can use this program for, like the kind of disputes?
Sure. It's the width and breadth of issues, coverages. It can be the removal of a tree and the cost incurred for that, or it can be the rain that came in after the roof was penetrated by a tree falling through the roof, or the roof was opened by the strength of the winds. And that rain that entered caused mold to develop between the sheetrock and the studs in the building. The original settlement between that policyholder and their insurer maybe was not aware of the mold, the dampness that was festering in the wall during the time that power was out and humidity was prevalent, and that mold started spreading. That has to be removed. It may be covered, it may not be covered, it may have a limit on the coverage available in the policy. All of those different issues in the very complex language that comes with any insurance policy is bewildering in many cases to lay people. And so a mediator in a relaxed conference room rather than courtroom atmosphere, with give and take and discussion and questioning back and forth, can sometimes make the situation more understandable and resolve disputes, because a lot of the angst that policyholders have, in my opinion, is the uncertainty about whether or not they are being treated fairly. They may not have a lawyer, they may not have a public adjuster, it may just be them, perhaps their contractor, who's telling them that the pandemic has caused huge increases in the cost of supplies and the cost of labor. Everywhere you go, people have signs in their front window or front door saying help wanted, whether it's a restaurant or a dry cleaners, you name it, a service station. They all have help wanted signs out because of the after effects of the pandemic. So I think even if you have had an initial payment and quote settlement, when we have our data call reports, the companies typically, they always show what they consider to be their percentage of claims that are closed. And the last report said 92% were claim of the claims for the 3 hurricanes of last year were closed. 62% of those with payment. We have large deductibles that are prevalent in many policies these days, in particular, frankly, with Allstate and State Farm, who have combined 36% of our homeowners market share And with that 36%, the majority probably still have a 5% named storm deductible. That is, for the typical policyholder, a $10,000 deductible. So therefore, 62% of claims were closed with payment, but 92% are considered closed, even though they are technically not. If there's unknown damage at the time of the settlement check that was tendered by the company, there's further damage discovered, or the cost of repair has turned out to be much higher than was anticipated when that initial settlement check was tendered.
And who pays the $600 fee for this mitigation program?
Well, I'm urging the companies to utilize it at $600, but there is no prohibition against the policyholder taking advantage of it as well, if they chose to pay $600 to access the services of one of these two mediation services.
And I was reading in the packet that was passed out that this will only take place within the Baton Rouge and New Orleans metro area. So say someone from LaFouche Parish, do they need to drive to New Orleans or Baton Rouge to have this?
Yes, that's how we did it last time in Katrina Rita. We had a facility set up in New Orleans and one in Lake Charles for each of the two storms, similar to what was done in Mississippi and Florida at Katrina, and then in Florida for the 4 storms the year before.
Commissioner, we also have a number of questions that have come in over Zoom. I'm going to try to summarize them, group them together for you. One is, how do policyholders sign up to take advantage of these mediation services? And what documents, what sort of information should they bring to the sessions?
Great question. Number one, they would sign up for it by reaching out to their insurer and asking their insurer to provide this mediation service for the dispute that the disagreement that still exists between the policyholder and its insurer. If that insurer is not responsive, they should call us, and we will file a complaint against that insurer for not responding, and reach out to that insurer and get a response on behalf of that policyholder. As to documents, any estimates, copy of your policy, your claim number and your policy number, whatever receipts you have for your expenses to date, including the attempt to minimize your damage, to close openings in your roof, tarps or what have you, that are prevalent throughout the impacted areas, photographs that were taken by the policyholder of their damaged property. In most cases, and I advise policyholders to do this, if they are hiring someone to put a covering over an opening in their property, make sure they get pictures taken before they put that covering on. So in addition to that, once a mediator is assigned to that individual policyholder, they will notify them of what documents they should be prepared to bring to that mediation.
Good. We also have several questions about whether the program is legally binding upon insurers, and does the mediation program affect a consumer's right to file suit at a later date if they needed to?
It is not binding on an insurer. It is voluntary. I think very much in the insurer's interest to do so. To not spend this $600, I think risk being penny wise and dollar foolish, because if they don't resolve that claim to the satisfaction of their policyholder, ultimately there will be litigation, and litigation becomes costly to all parties, including to the insurer. It does not, the mediation program, if it's not successful, does not impact the policyholder's right to continue on in their negotiations with their insurer, and ultimately, if need be, file suit. If the mediation is successful, in most cases, the insurer will require an agreement be entered into to resolve all claims under all exposure under that policy for that event.
We also have some questions about the interaction between deductibles and the amount of damage. You've stated that the limit of the program is $50,000. So one question is, if you had $60,000 of damage to your home and a $10,000 deductible on your property, would that situation be eligible for mediation under this program?
And it would, under what we have entered, the agreement we've entered into with these two mediation firms. The $50,000 limit is net of whatever deductible is applicable to that residential claim.
And if someone wanted to do a mediation remotely by Zoom, would they be able to?
Good question. And I would assume so, because these mediation firms are both big players in both markets. And I would assume they've been doing them by Zoom for the past year and a half during the pandemic. But frankly, I have not discussed that with the firms, but we can get that answer for anyone who is interested in doing it through the virtual means.
And how long will this program last for?
Well, it's set up, and it was initiated last Friday and set to sunset on June 30th. That's all the commitment we have from the providers, from the mediator providers. It is possible, I might even say probable, if it's as successful and in demand as I hope and anticipate it will be, that it will be extended beyond that June 30th sunset. But for now, the proposal is from now through June 30th of next year.
Thank you. I think that covers it.
Okay. Any else? Good. Oh, yeah.
Is this agreement costing the state anything?
Not a penny. No. We reached out to the mediation firms and said, give us the best price you can, and they agreed at $600. We did a little negotiating, but it didn't change it terribly much. So thank you. Thank you all.